if you are characterized by the jury as the initial aggressor, it's pretty much over at that point. I think the hardest thing for me to do as a defense lawyer in a self-defense case is trying to deal with a bad statement by the defender.
This is the In Self Defense podcast with Don West, Steve Moses, and Sean Vincent, exploring high-profile self-defense cases and identifying the lessons learned for concealed carriers. Hey everybody, I'm Sean Vincent. Thanks for joining us today. Our topic today is going to be a question that we're often asked by CCW Safe members and by concealed carriers, and it's essentially this: how can somebody who's innocent be found guilty and convicted in a self-defense case? And when we talk about innocence, we're talking really specifically about someone who is justified. In a court of law in the American criminal justice system, people are considered innocent until proven guilty, but the only verdict that a jury can come to is guilty or not guilty. So what we're really asking is, how can someone be justified and then found guilty in a court of law? And when we say justified, we mean that the defender must have had a reasonable belief that they face the imminent threat of great bodily injury or death at the hands of another. Once a self-defense claim has been made, it's up to the prosecutor to disprove that claim of self-defense, and it's a pretty high standard. But if there's controversy about any of the key elements of the self-defense claim, then the prosecutor could turn the jury against the defender and wind up with a conviction. I'll be joined today by Don West. He's National Trial Counsel for CCW Safe and a veteran criminal defense attorney. And we're going to explore some of these controversial issues that could cause an innocent person to be convicted. Some of these issues that we'll talk about will illustrate why you need competent counsel that understands the nuances of self-defense law. But there'll be other things that we talk about that will illustrate ways that you, as a concealed carrier, can comport yourself that will remove some of the ambiguity, will remove some of the controversy from a potential use of deadly force in a self-defense scenario. During the course of this conversation, we're going to talk about the Stephen Maddox case. Stephen Maddox is and was a CCW Safe member. He was charged with murder in a self-defense shooting. CCW Safe was on his side. He was acquitted after a very short jury deliberation. We talk about Stephen's case only because he expressly gave us permission to use the lessons from his case so that other concealed carriers like you could benefit from his experience. With that, let's get to it. Here's my conversation with Don West on how an innocent person can be convicted in a self-defense case. And just to assuage some concerns from concealed carriers, I think we hear about in the press the controversial cases. There are lots and lots and lots of self-defense cases where all those elements are clear to the responding officers and to investigators, and charges are not filed. Sometimes there's going to be an investigation for sure in any homicide, but sometimes it's pretty clear they're crossing T's and dotting I's, and they're satisfied that it was self-defense. There are other cases where the self-defense claim is so thin that it clearly looks like something else was at play, and those are likely to be charged. But those, I think you mentioned this to me, are often going to be pled out or resolved in some other way before that defendant goes all in at trial on a self-defense claim. And so the result is that the cases that we get are ones where there's really usually only one or two elements where there's controversy.
Yeah, that's right. Usually, if you're trying to pare the cases that are in the system down for the cases that are the most likely to wind up in trial, you can cut off both ends. And by that, I mean, when it's pretty evident to the responding officers and the detectives that it was self-defense. In a sense, the stories match up. There might have been a witness that corroborates what the accused said.
It fits the evidence.
There's going to be physical evidence that's consistent with the way it was explained. And that opens up a whole other issue of how much do you say to the police if the police are on their way and you've been involved in a lethal self-defense shooting. But assuming the police have some stuff to work with and the physical evidence matches up, some of the other stuff fits as well. There's no significant criminal record. There's no prior bad blood. There's no other reason to question what seems to be a pretty straightforward case of self-defense. Sometimes there's an arrest, but no prosecution. Sometimes there's no arrest at all. And so those cases kind of go away. The prosecutor will decide there's simply not enough evidence to prove beyond a reasonable doubt it wasn't self-defense.
Right.
And then on the other end of this, some of the claims of self-defense appear to be so strained and tenuous. There's physical evidence that rebuts the statements that were made. There are witnesses. There may be history of bad blood. There could be threats, prior threats. There could be this stuff on the internet that out there that makes the person look predisposed to violence. There could be any number of things that causes law enforcement to really question the claim of self-defense, and for good reason. So once that stuff comes out and then everyone's looking at the full range of the evidence and the picture of the case, it's pretty clear you go to trial and lose, you're going to prison for a long time, because self-defense cases are sort of all or nothing.
Right.
Most cases, there's some chance there will be a lesser included charge. There'll be other stuff that might impact the decision to go to trial. But in a self-defense case, since you are effectively admitting to the crime of criminal homicide, and to some degree, if you're convicted, there may be a lengthy mandatory minimum prison sentence. The sentencing guidelines in virtually every jurisdiction are going to be high when someone dies. So it's an all or nothing thing. So the cases where guilt seems to be pretty clear and not much way to explain your way out of it, those cases also go away.
Yeah.
Because they're pled out, which is the term for when there's an agreement reached between the prosecutor and the defense to resolve the case short of trial, typically with a plea to a lesser charge or an agreed upon sentence that's often then embodied in a plea agreement, goes before the court accepts the plea agreement, and the sentence is imposed, and it's typically far less than one might have received had they lost at trial, but it's certainly more than had they been acquitted.
If you don't mind, I'd like to talk about that in one point, because I wanted, you just gave a whole list of examples of things that can cause a complication in a controversial self-defense case. And these are the things where if it goes against the armed defender who believes they're justified, who believes they're innocent, they can end up convicted. And this is something that people don't think about a lot. You just talked about this. If there is some significant controversy where the defender feels that there's a strong chance that if the jury goes against them, they can go spend perhaps the rest of their life in jail. Mm-hmm. But there is an opportunity there to plead to a lesser charge. There is some incentive for that to be considered, right? Because if you could maybe plead to a charge that would see you in jail for 3 years, and that would save you the chance of potentially going to jail for the rest of your life, that's something that you'd have to think about. And I'm thinking about, we've talked a lot about the Gerald Streebent case.
Right.
Gerald Streebent's a veteran Marine sniper. He was a UFC fighter, a professional fighter. And he had a accident. He was rear-ended on a dark highway at night. He didn't know it, but the motorist who hit him was drunk and acting irrational. The motorist got out of his car. His name was David Crowfoot. He's yelling obscenities. He's making threats. He's acting aggressively. Streebent happened to had a rifle in his vehicle. He got it. He was armed. He asked Crowfoot to stay back, stay back. He called 911 to report it. Crowfoot got close enough that he actually touched the rifle at one point, and Streebent felt he had exhausted all these opportunities, and he fired one shot, struck Crowfoot in the forehead, killed him. But there were all sorts of questions about, was he brake checking? Did he instigate the event? He had posted stuff on social media about being an aggressive driver, and I'll strike like a cobra if you don't drive fast enough. He'd done lots of things. There's some stuff in his background that his attorney called the parade of horribles, some character evidence that was going to be adverse to him. Plus, he was denied bond, so he was in jail while they're proceeding towards trial. And the lawyer in that case was able to get the prosecutor to agree, partly because there was evidence that the attacker had touched the gun, and he did have a 911 call where he was asking for help and reporting the threat. They agreed to really just like another couple of years in jail beyond what he had already served, as an alternative to going to trial and potentially serving the rest of his life in jail. So I had a chance to do a little work on that case. You and I have discussed it. I believe that in most ways, this guy was justified at the moment that he pulled the trigger, but that it was complicated. And so let's just say in that case, he's innocent and he was justified. He went to jail anyway. It was probably a good decision, because there's a high chance he could have been convicted. But there's a situation where you have a innocent person convicted, because pleading to a charge is being convicted and serving time in jail.
Yeah, I think that's a good illustration of how these things can play out. And in my mind, from what I know about the case and my prior conversations with you, Gerald Striebman did believe that he acted lawfully under the circumstances. And that's a reasonable belief under those circumstances.
Yeah.
Unfortunately, he had a lot of baggage that he brought into the trial with him that may very well have poisoned the jury when they did their own assessment of the objective assessment of whether under all those circumstances he did really in fact act reasonably, or some of the statements he'd made, some of his prior history, was that going to impact the jury in such a way that he was looked at as an aggressor. For example,
Right.
If you are characterized by the jury as the initial aggressor, it's pretty much over at that point.
Yeah.
So that's a huge, huge risk. Of course, in many jurisdictions, if you are convicted of second-degree murder, much less first-degree murder, you're looking at a life sentence and many times a mandatory sentence of 20, 25 years, or even life, especially in those jurisdictions where there are enhancements because of the use of a firearm. So it's not a low stakes proposition by
Right.
any means.
Yeah.
And in Striebman's case, trying to get into the mind of him and perhaps his lawyer a little bit,
Yeah.
from day one, he was accruing what we'll call credit for time served. So since he didn't get bail, by the time this thing came on, he probably had a year or close to it that he would have gotten credit for, that he wasn't going to get back if he was acquitted, but would apply to any sentence that was imposed. So when you said a couple of more years, that probably means the sentence he got minus the time he'd already served.
Yeah, which if I recall, was almost 2 years already.
And he may have had the opportunity to earn some good time, some credit off his sentence once it was actually imposed. So that's a hard decision to make.
Yeah.
And because when you roll the dice at trial, of course, you've lost all control. You can do the very best. Your lawyer can do the very best. But if any one thing goes wrong that tips the scale against you, even if it's unfair, even if you essentially were the victim of a bad ruling by the judge, or of a bad jury instruction, or any number of things can go wrong that can put you in that position where all of a sudden your good case looks terrible, and then you get convicted, and then your recourse is appeal, which is a pretty bad spot to start your sentence from, is hoping that in a couple of years you'll be able to convince the appellate court that you should get a new trial.
Right, a couple of years spent in prison, and like you just gave a rain shower of things that could cause somebody to lose a self-defense case. Let's talk about a couple of those. You said a moment or two ago that if the jury believes that you were the first aggressor, that essentially scuttles the self-defense claim. I mean, that's a real killer and a claim, is. Right? And so, and here's why, and this is where this can be something that's in controversy, because often I think armed defenders, we like to think that our self-defense scenario, if we're ever faced with one, is going to be someone dressed in a black uniform carrying a club or a knife or a gun breaks into our house, and it's this very clear-cut instance, or we are mugged by an armed mugger on the street. But we know that a lot of the messy self-defense cases start over, let's say, a road rage instance where people are yelling at each other, or some argument outside of a bar that goes off the rails and escalates.
A parking space. I've seen those cases more than once. The whole thing started because someone thought the other person was disrespecting them or something.
Or sure, the parking, like Michael Draca, who approached this girl for parking in a handicapped parking spot, and her boyfriend came out to defend her honor and shoves him to the ground, and then he shoots the guy, and now there's a self-defense case and a manslaughter trial.
Right, unfolds. And Michael Drake is in prison for a long time, and McLaughlin, is that?
Yeah, Marquise McLaughlin is dead.
Is dead. Yeah. So and that's the thing, I think, Shawn, that you can illustrate so clearly is you don't know when and how these things may start, but they can start, and often do, under the most unusual circumstances, in a situation that most people typically can resolve with a wave of the hand, or, hey, buddy, that was mine. Oh, all right, you take it. Whatever it is, whether it's driving down the road and you cut somebody off, whether it's jockeying for that parking spot in a busy intersection or busy parking lot, whatever, though, once it starts, we have seen those firsthand, that it can escalate to the point of somebody drawing a weapon, displaying the weapon, and then ultimately shooting that weapon, and then having to explain ultimately what it was that they were thinking, why they were thinking that in their mind justified the use of lethal force.
Let's
all because of something that we look in retrospect as silly.
Well, and I think even the shooters will often admit was silly, and after the fact when they're facing this prosecution. Both of these cases we talked about, Gerald Strebent and Michael Draca, we referenced there. In those cases, they also were facing a threat that turned out to be unarmed. And so we when we're looking at how can somebody who is justified or believes they're justified be convicted in a self-defense shooting, there's, besides being the first aggressor and picking the fight, or being perceived as picking the fight, there's almost no quicker way to get a conviction or to strike controversy than shooting an unarmed person. And I think you've explained well that just because they're unarmed doesn't mean they're not dangerous and capable of inflicting great bodily injury or death, right? But it makes it harder for a jury to buy it.
Yeah, I've been involved in a number of self-defense cases and tried a number of self-defense cases, but the ones in my personal professional experience and from the work that we've been doing that are the most likely to go to trial and the hardest to defend against, although the law supports you if the facts are there, the hardest to self-defense to defend because of I think the bias and prejudice against the armed defender in these scenarios is when, in fact, the person that was killed in the self-defense confrontation was considered to be unarmed, meaning they didn't have a knife or a gun or a baseball bat that was evidently able and they were willing to use it and could. But when it's hands against a gun or feet against a gun or something against a gun, I think there's probably a built-in bias in the entire system, beginning with the police, to the prosecutor, to the jury, and frankly, everyone else that you talk to about and say, I shot and killed an unarmed man, but it was in self-defense. Then you get, oh, yeah, right.
Yeah. Well, I mean, and so to draw a specific example and to kind of leverage off of the initial aggressor road rage thing we talked about a moment ago, you recall the case of Ronald Gasser, who shot former NFL star Joe McKnight after what the police call a tit for tat road rage incident that went on for miles. Right? Somebody cut somebody off. That's right. Who did what first doesn't even matter at this point because those weren't crimes, but they just kept racing after each other and cutting each other off again and again until they both got to this intersection outside of New Orleans. Coincidentally, an intersection where Ronald Gasser had gotten into a fight with somebody after a road rage incident before. That didn't help him out at all. We'll get to that later. But he rolls down his window and he actually waves McKnight over to his vehicle. McKnight comes over. He's unarmed. He kind of like leans into the window. And then Gasser says that at that point he felt like he was about to be attacked. He had already pulled his gun out, had it on the seat, and he shot him. And that there's the initial aggressor question there that we addressed before, but also McKnight did have a gun in his vehicle. He chose not to bring it with him.
That's right. Yes.
So what's the classic phrase that it was Ronald Gasser who brought a gun to a fist fight in that case, and that didn't go well for him at trial.
No, it didn't, and there was clear evidence, I think, that McKnight approached the car, may even have reached through the window, may have been physically able to put his hands on Gasser. I don't know all of how the forensics played out. And in most places, if you enter the compartment of an occupied vehicle, that in itself is a pretty serious crime. Although I think what the jury did in this case is looked past all of that and really looked at the dynamics between the two people, the length of the chase and the confrontation there at the stoplight. And then ultimately, I think it was probably Gasser's prior history of a similar situation that did not result in shots fired. It was his undoing. Let me just add to that, since we're talking about initiating who's first aggressor.
Yeah.
There's also another theme that relates to that. There's the initial aggressor, but there's also the concept of provocation.
Yes.
Provocation's just as good as being the initial aggressor to keep you from being able to claim self-defense. The notion of provocation is that what you're essentially doing is baiting the other person to use some sort of violence against you or some threat of violence that you can then use as an excuse to use violence against them.
Right.
That you're essentially set them up to threaten you or swing at you, that this here, knock this off my shoulder, the old Robert Conrad Duracell commercial.
Right.
All those years ago that some of our audience will know. They'll remember both Robert Conrad and those particular commercials.
The ones that still own vinyl records, right? Yeah.
Yeah.
Well, you used the word bait. So let's talk about the Marcus Karma case, right? So Missoula, Montana, Marcus Karma had somebody break into his, well, they didn't really break in. He had left his garage open at night so that he could go smoke out there every once in a while. Someone came in under the half-opened garage door, stole some valuables from him. He was upset about it. Was angry. What he did is he continued to leave his garage door intentionally open. He even went so far as to take his common law wife's old purse and some expired credit cards and put it like on the trunk of the car that was parked there. He set up a video baby monitor in the garage so he could look. And he kept a shotgun loaded, leaning next to his front door. And then one night around midnight, he happened to catch a shadow in his garage of a silhouette of a person moving around. And he grabbed the shotgun, went out the front door, came around to the front of his house, and fired into the uh, darkened open garage and killed what ended up being a 16-year-old foreign exchange student who was most likely trying to steal beer from his refrigerator. He manufactured a circumstance where he felt he'd be justified in using deadly force.
Yeah, I think, of course, maybe maybe he was thinking that, well, this is castle doctrine, that my home is my castle, and anyone that breaches the doorstep or the threshold of the garage door is fair game. Nothing else matters. It doesn't matter how and why they came in there. Once they are in my house, I can shoot and kill them. Well, obviously, he's wrong. If that's what he thought and he was acting lawfully in his own mind, that's an example of how a subjective belief is simply unreasonable. It's illegal and unreasonable, and there's no way that a jury, if properly instructed, is going to accept that belief as justification for lethal, the lethal use of force. So even if you gave him the benefit of the doubt, and I think there's plenty of facts in that case that would suggest he doesn't deserve the benefit of the doubt on what he had in mind.
Especially considering some statements he made before and after the shooting. Yeah. But if you create the circumstances that then seem to you at least to justify the use of deadly force, that can and will be used against you in a court of law. And it's pretty devastating to your self-defense claim.
And it doesn't have to be setting up a trap in your garage. I think people that have a misunderstanding of stand your ground, which means, yes, if you are threatened, that imminent threat of great bodily harm or death means that in a stand your ground state, you don't have to retreat, even if you otherwise could retreat. That doesn't give you license to shoot anybody in front of you. It's not licensed to commit murder. What you do in stand your ground still has to be reasonable, and it has to be determined to be reasonable by the jury. So that's treacherous stuff there. And that's why my typical advice when someone asks me about stand your ground is, yes, it's a very valuable principle for the law. It's valuable for a defense lawyer to have in the explanation to a jury. But it's not something I recommend people rely on if there's any way for them to retreat safely. Because first of all, by retreating safely and disengaging, nobody gets shot and killed, which is absolutely the best place to start from.
Right. That's how you're actually innocent, is if you didn't commit a homicide, no matter how justified you felt. And
one of the other myths that we've seen, I think it was even in the Gasser case, is that people will the Tooler research that had then
the 21-foot rule,
the 21-foot rule, the Tooler drill. I think it may have been even Michael Draka that alluded to the 21-foot rule. And people mistakenly think that if someone crosses that 21-foot mark that they have, I guess, mentally drawn around them, that they're fair game too. So automatically, well, he's only 19 feet away from me, so I guess I can shoot him no matter what. And of course, that's not true either. It always matters what. No matter what, you have to still be reasonably convinced, and you must believe that you are facing an imminent threat of great bodily harm or death, no matter how far or close the person is. The 21-foot rule helps you gauge that and helps you act in such a way that you can actually save your own life if someone truly is charging you and has the ability with an instrument of some sort to kill you. Then that helps go into the calculus, and it will also go into the analysis by others as to whether you acted reasonably. But that's not any license to shoot by any means.
So we talked about how in the Marcus Karma case, he'd made comments before and after that hurt his case. Beforehand, he was saying that essentially he was going to get the people who robbed him, and afterwards suggesting that he had basically done the world a favor by shooting the burglar or the suspected burglar. Even Ronald Gasser, we alluded to the fact that he had a road rage use of force fist fight at that same intersection in the past. I had a friend once who had we'll call him a mentor on the streets of Detroit, where there's a lot of crime. And these kids got in trouble a lot. And he said, hey, only you can tell on you, right? And that when it comes to people being convicted of what could otherwise be clearly justified self-defense, it's them opening up their big mouths, either after the event when they're talking to investigators or beforehand on social media, or we've got perhaps more than any other one of these things that we're going to talk about, ways that someone can get convicted of justifiable use of force is by saying the wrong things too often to the wrong people in the wrong places. Some of these shooters are their own worst enemy.
I think the hardest thing for me to do as a defense lawyer in a self-defense case, a good self-defense case factually, one where it all seems to line up from the forensic analysis, from eyewitness testimony and all of that, is trying to deal with a bad statement by the defender, by the accused. An ill-considered statement, maybe a statement made out of nervousness or panic because they're being questioned.
Right.
Anything that's inconsistent with some other statement that was made. When you have to explain how that could happen, how could someone make two different statements about the same thing if they were actually acting in self-defense? That is so challenging for the defense lawyer to figure out. How do you respond when the prosecutor says, well, were you lying then or are you lying now?
Yeah. Well, and let's use a real subtle example of that in a kind of a heartbreaking case. And we're going to talk about Ted Wafer up in Dearborn, Michigan. So Ted's alone in his house. He fell asleep in front of the TV. It's, let's say, around 4 a.m. And all of a sudden there's this violent pounding on his door. He can't find his cell phone because he left it in the pocket of his pants that he hung on the bathroom door. He's frightened. He grabs his shotgun and waits, and there's this pause in the knocking. It hasn't happened in a while. He thinks, I'm going to open up the front door and see what's going on out there. And there is this silhouette of this figure standing right in front of the door. He opens the door. That person tries to push through the screen, and the shotgun is fired. It hits what turned out to be a teenager, like an 18-year-old girl, in the head.
Right.
She's dead instantly. He tells the police that basically the gun went off on accident. And so we talk about this case a lot. There's no such thing as accidental self-defense. You did it because you feared imminent bodily harm or death. You can't do that on accident if it's deliberate to defend yourself. And that was just fatal for his case.
Yeah, that's a good way to illustrate it, that if you are acting in self-defense, you are engaging in a sequence of behavior that's purposeful and intentional and should be in response to what you are seeing is unfolding around you. If you act on accident, if you act by accident, then you are doing something that you are saying you did not intend to do.
Right.
Absent a defect in the firearm that would somehow cause it to go off on its own, and there's no suggestion in Mr. Wafer's case that happened. What that means is somehow he depressed the trigger of the shotgun and didn't mean to.
Right.
I guess that's what what he's actually saying is, somehow I pulled the trigger. I didn't mean to pull the trigger, but the gun went off and killed this young woman. So had he had the right to intentionally pull the trigger and intentionally deploy lethal force under those circumstances, and he had a pretty good argument that he did under all of the facts and circumstances of the incident, the pounding, the insistence. There was some time where it was clear someone was trying to break in.
Right.
Obviously, Mr.
Wafer
made several tactical mistakes, some horrible judgment and decisions.
But he's a sympathetic guy.
Yeah. It was his own home in the middle of the night. And there's at least a plausible argument that he legally acted in self-defense if he had actually intentionally pulled the trigger. But to create the hurdles for his lawyer, who could have made an argument that a jury could have concluded at the end of that trial, we might not like it. We may have some questions, but we can't say the prosecutor has convinced us beyond a reasonable doubt it couldn't have been self-defense.
Yeah.
And he could have been acquitted. And in fact, once he muddies things and mucks up the whole defense by saying it happened by accident, he's essentially taken away the prosecutor's best, the defense lawyer's best arguments against the prosecutor.
Yeah. And so, and it could be I believe that he probably said that because he felt like he needed to mitigate things a little bit. He didn't realize he was destroying his self-defense claim when he said that. He was trying to show that he's not a murderer, right?
Mm-hmm.
And there are other things. We talk a lot about consciousness of guilt evidence. And there's some cases we looked at. I'm going to use the Jarrell Lee case, right? This is a guy, he and his cousin, they're hanging out on New Year's Eve. There's this guy named Michael Epps, who's quote unquote, according to the paper, a known troublemaker. They've had a little beef on and off throughout the night. They go and they have a verbal confrontation with that guy. A fight breaks out. It's Quentin Epps. Quentin Epps shoots Jarrell Lee's cousin and then turns the gun towards Jarrell Lee. Jarrell Lee had a pistol himself. He shot first. He defended himself. But then here's what he does. He runs from the scene. He hides his gun and he fails to call 911. So when police find him the next day, not only do they think that he murdered Quentin Epps, but also he's the suspect for the murder of his own cousin, who he absolutely did not shoot. The Cato Institute wrote a friend of the court brief in this case after this guy was convicted of murder in this case, and raising the question, how can somebody who just witnessed the murder of his cousin and was about to be shot himself be convicted for using deadly force in self-defense? Part of that, there's a lot of things he did wrong, like the confusion about who was the initial aggressor in that case, leaving a place of safety to go maybe pick a fight. But also, innocent people, we don't think that they're going to flee the scene, hide the murder weapon, and not call 911, right?
No, but you could and still be innocent.
Sure.
Yes, you absolutely can be innocent and do all of those things, but who does that, right?
Well, it's difficult to explain to a jury.
Yes, it's very difficult to explain because the jury, I think, is looking at you, trying to understand your thinking, trying to understand whether what you did in the perceiving the situation that results in you using deadly force, whether, and then your conduct afterwards, they look at that from, I think we would be naive to think that they aren't simply asking themselves, what would I do in the same situation? I am a reasonable person. I've gotten through life all these years without being a convicted criminal or getting killed myself. So I'm reasonable. I know what to do. And they would say, would I have done that? And if they say no, that's the first strike against you for them deciding that what you did was reasonable. Doesn't mean they can't. Doesn't mean they can say, well, I wouldn't have done it, but even though he did, I don't think it was unreasonable. You just got so much to undo, so much explaining to do, that you've dug yourself a hole before you ever have a chance. So that doesn't mean that you can't flee the scene after a lethal self-defense incident. What it does mean, though, you don't flee to get away so you're not caught. You flee to get away to a position of safety where you can call the police, or where you're with some friends so that those people at the scene can't go after you.
Sure.
So it's not fleeing the scene to avoid responsibility. It's getting out of there so you are safe.
Yes. And then
I can't think of a good reason, though, to hide the gun, other than you're just fearful that you're going to get arrested if you don't get away with this somehow, because you're scared of the system. Sure. You're scared of the people.
Well,
even if how do you justify, I'm not scared of what I did. I did something that I had to do under the circumstances. I just
did it. A lot of that comes up when maybe they're illegally holding that gun, or they have some other problem with law enforcement, and they don't want to get caught for that. There's lots of reasons to do it. I worked on a case that wasn't a firearms case, but it was a self-defense case where the defender pushed somebody who had attacked his girlfriend, and the guy was so drunk that he wobbled out of this bar in between these cars and got hit by a car. And our guy, who I'm sure had been drinking a little bit, was shocked by this. And then somebody came up and said, "Oh, dude, that's a homicide." And he was just in a bad mental space and freaked out. And his instinct was to run. And he did. I mean, he quickly realized what was going on and came back and turned himself in. But I don't know if that case even gets charged if he didn't run away from it. And it was something that his lawyer had to explain at trial. It did a good job. There was an acquittal in that case. But what a nightmare for what was understandable action when put into proper context, but which at first made him look guilty. Consciousness of guilt.
So consciousness of guilt can arise after the incident itself by what you do, by fleeing. That is really seen by the jury as trying to get away from it and with it to avoid prosecution. That's the consciousness of guilt that's associated with fleeing. Tampering with evidence, hiding evidence, destroying evidence is seen by the jury and the prosecutor clearly as an attempt to get away with it, meaning not being prosecuted. And all the other stuff that comes with trying to hide your involvement in something, whereas we've talked about from the beginning and continue to talk about how a true self-defense case is one that you acknowledge your involvement, your decisions, and then claim that you were justified.
And he talked about manipulating evidence, like in the Dean Cumming case. That's the guy who got in a fight with his landlord, essentially, on this remote property in the desert. He was outside the cell range, so before he actually called it in and reported it, he cleaned himself. He'd been sprayed with pepper spray, is what it looks like he was. But he soaked his clothes and washed his face, and that made the investigators very suspicious. And they accused him, actually, at one point. I think they dropped this charge, but they accused him of tampering with evidence in that case. So things that even seem innocuous, maybe to you at the time, could be seen as manipulating the scene and tampering with the evidence, which is therefore consciousness of guilt evidence potentially.
Yeah, and the after incident stuff that we've talked about all sort of reflects on that. It's just more stuff to have to explain. And in most instances, in every instance where, in fact, the incident was necessary self-defense, then there is an explanation. You just wish you didn't have to have an explanation because you wish you hadn't done something that requires it. While we're on the subject, of course, there's lots of stuff that you can do prior to being involved in a self-defense incident that sets the stage, feeding into the prosecutor's theories of this wasn't lawful self-defense, this was revenge, this was anger, this was a guy who was predisposed and just looking for someone to be violent against. And you can do that through any number of things. Running your mouth, the stuff you wear.
Yeah, if you self-publish a novella on Amazon about shooting a migrant crossing your borderlands ranch, and then you later shoot a migrant crossing your borderlands ranch, that might be used against you.
I'm smiling because George Kelly, it's not a laughing matter. He's being prosecuted. He killed somebody. I'm smiling because in some ways the novella almost seemed like a self-fulfilling prophecy. He's
Yes.
almost forecasting what he wants to do, and then through circumstance or what have you, all of us, there is that incident that takes place. And for those of our listeners and that don't know that case, it's an interesting factual thing. He made lots of mistakes, and it's emblematic representative of some of the problems that ranchers are having dealing with the border crisis.
Yeah, but you don't have to write a novella to sort of cast suspicious doubt upon yourself. It could be as simple as maybe a bumper sticker that has the profile of a 357 Magnum that says, "I'm your Huckleberry," like referencing the Doc Holliday line from the Tombstone movie. Or I saw on a fence around a auto body shop one time a sign that says, it had the silhouette of a pistol, and it says, "We don't call 911," essentially saying that they will be happy to shoot you for trespassing without calling the police. And if you happen to later shoot someone for trespassing, or have maybe even a justifiable self-defense encounter on your property, and that sign's on there, the prosecutor might use that against you.
Oh my goodness, there's no lengths to which prosecutors won't go if they think they can get some traction with something like that. A real life example, remember CCW Safe member Stephen Maddox was involved in the murder trial, first degree murder, prosecuted for first degree murder, mandatory life in prison had he been convicted. And several years before this incident, he got a personalized license plate that was Red Rum. Red Rum was a license plate that had gotten several years before this fatal encounter with a guy. And the prosecutor attempted to show the jury that Red Rum is murder spelled backwards, as if to suggest that somehow, because he had a license plate with murder spelled backwards, that was a window into his mind about what was happening when he shot and killed the guy that attacked him 3 times. So extraordinary.
Yeah, and so that opens up another area of inquiry for us, right? That's a bad fact, and it doesn't necessarily, and certainly doesn't mean that he's guilty, because I'll remind our listeners that Stephen Maddox was acquitted after little more than an hour of jury deliberations, and in large part to the work you did on the case and the lawyers that you found to represent him through the CCW Safe. But remember Paul Harvey, and he'd talk, and he'd say, and that's the rest of the story, right? Here's something I'm fascinated by, sort of intellectually, and it becomes really important in cases, is that there's this body of, we'll call it a body of evidence. You and I know that evidence doesn't become evidence until it's introduced in trial, right? But there's what we call discovery. There's all these artifacts and statements and testimony that can possibly be considered by a jury at trial. Now, the lawyers involved might not, and certainly won't, choose to introduce all of it. And sometimes, as on the defense side, will want to introduce some piece of evidence that the prosecutors object to. And in that case, the judge has to decide. Conversely, like in the case of this Red Rum license plate, the prosecutors might want to introduce evidence that the defense objects to, and then the judge will rule. And the judge has to use their discretion, and there's different standards for that. The whole evidentiary code is long and thick, and the source of a lot of law school discussions. But the point is that all the facts that you think might be on your side in a case might not make it to a jury, and there might be things that you don't even know about that exist as evidence that could come in that could cause you a real problem. And the judge is the gatekeeper of all of that.
Exactly right. So if you have key information that you have acquired somehow during the course of the investigation, you may have hired private investigators. They may have come up with information that you didn't know before, that the police don't know, the prosecutor doesn't know. It could be against a prosecution witness. It could be in favor of your case. It could be something that you think will have an impact on the jury that will be favorable to you. It might be enough of a push that the jury will then believe you when you're saying you acted in self-defense. And when the judge is the gatekeeper, what you're saying there, Shawn, is that regardless of which side it is that wants to introduce evidence, the judge has to make that preliminary decision, whether it's admissible or not.
Yeah.
Most stuff just comes in routinely because everybody knows generally what's admissible and what isn't.
Sure, a shell casing's coming in unless there's some reason to think it's not part of that case, right?
Yeah, a confession is coming in unless it was clearly beaten out of the person or there was some improper promise or suggestion that makes it suppressible. And that stuff would be dealt with prior to the trial. There'd be a motion to suppress filed saying that this statement or this confession isn't reliable because of the circumstances under which it was given. And search and seizure evidence is suppressed because of the manner in which it was taken without a warrant or et cetera.
Yeah.
Et cetera. But there's all sorts of little stuff, stuff that has some probative value, but may also have some prejudice.
Yeah.
So this gatekeeping process is typically known in legal parlance as a 403 determination. That's mostly because evidence codes in most jurisdictions use the subpart 403 to identify that kind of evidence, where the judge has to enter into an analysis of whether the probative value of it, meaning the reason why you want it introduced, and why what value it might have, is substantially outweighed.
Let me throw in an example of that so our listeners can understand. We talked about the Michael Drake case where he approached the woman in the parking lot, and Marquise McLaughlin came out and shoved him to the ground, and Drake shot him. Right, that was captured on the surveillance video, the security video of this convenience store where it happened.
That's right.
And the tape was outside; it was inside, so it shows the whole incident. It shows Marquise McLaughlin walk up to Drake. It shows him shove him to the ground. It shows Drake draw the gun, fire, hit McLaughlin. And then McLaughlin actually staggers off. He had been struck in the heart. He didn't know this yet, but he staggers off and goes back inside the convenience store. There's footage of McLaughlin falling to his knees and dying on the floor of this convenience store while his son came and watched him die. And so at trial, the judge decided that the portion of the video that shows the actual gunshot and the altercation was allowable, but made the correct call in my opinion, to not let the jury see the guy die grasping his chest at the feet of his 5-year-old child, because that would have been more prejudicial than any value it would give on to whether or not he was justified in using self-defense.
So let me ask you, are you saying the prosecutor wanted that piece of video in and would have been more than content to let the jury see this man die in the presence of his
Absolutely.
child?
And the defense attorneys fought to keep it out and fought successfully to do so. But can you imagine? I mean, the guy he got convicted, but do you imagine how much harder it would have been if he had to see that?
Well, that's a perfect example of prejudice.
Yes.
And also a perfect example of how there is little, if any, probative value to that. All of the important stuff was coming in on video. the stuff that happened later, the moment that he actually died and where he was when he actually died, had nothing to do with whether or not Michael Draco was guilty.
Mm-hmm.
And yet it would have appealed to the emotions of the jury, obviously.
Right.
And it may very well have tainted the whole proceeding. In a close case, obviously, those kinds of dramatic and emotional, that kind of evidence has a powerful impact. That's why a judge will often limit the number of autopsy photos, for example, that's entered into a case.
While we're talking about evidence, though, I wanted to talk about how much you don't know the full body of discovery that's available. And a lot of it is open to interpretation. And in fact, could be disputed even scientifically. And what one side thinks the gunshot residue on somebody's clothes means, the other side might have an expert that disputes that. And what might seem to you as clear evidence of your justification could be interpreted a different way and used against you. And you have to be ready to argue things that you couldn't possibly ever have imagined you'd be arguing in a self-defense case, like video evidence. Gunpowder residue is more obvious, but we go to my cousin Vinny, tire track marks, right? There's things that that you couldn't imagine that are going to become big voice identification. We have experience with, right, Don?
Yeah, obviously in the Zimmerman case, there was this recording in the background of the 911 call one of the neighbors made during the actual physical engagement of Trayvon Martin and George Zimmerman, where you could hear the single gunshot at the end clearly in the background. So,
but there's desperate screaming heard on there for many seconds.
Desperate screaming. I think what everyone agreed with that heard those screams was that person was in dire straits. That person was scared. They were desperate for some help.
Yes.
So obviously, whether that person was Trayvon Martin or whether that person was George Zimmerman had a lot to do with how the jury was going, and everyone was going to see that case.
And the state conjured up some. I think at this point it's been long enough, and since we won and we were right, we can call them crackpot experts that come in and, in my opinion, distort science and the basic standards for that type of discipline to try to testify that it was Trayvon Martin. And you led our effort with actual real experts who used real science and proven methods to show that it was inconclusive. I hope I'm not displaying my prejudice or bias here when I say that, Don, but
we had phenomenal experts that were credentialed, that were preeminent, that were international experts, and they came in and made a clear record, I think, that would have sustained our position on appeal, which is a big part of trying any case, of course, is preserving the record so that if there are mistakes made, that they are reviewable by the appellate court. Because if you lose, you lose. I mean, you can't control the verdict. You can do the absolute best you can along the way to get the best and most favorable outcome, but you can't control it. And once it's in, it's in.
Yeah.
And then you may be stuck having to appeal. Your comment, Shawn, I think, about some of this forensic stuff, about interpreting and misinterpreting and mischaracterizing is really important for a couple of reasons. One, it underscores the need to have experienced, competent counsel, because the lawyer is going to be leading the team that's going to put on the defense, but also is going to be in charge of analyzing the evidence. You're going to get material through discovery. You're going to get probably expert witness reports from the prosecution witnesses, but you also have the opportunity to do your own investigation, hire investigators, hire other experts. And often those experts will be asked to re-examine the evidence to conclude, did the prosecution experts get it right? Or did they mistake an entrance wound for an exit wound? Did they examine the clothing for gunshot residue? Are there conclusions that can be made through that examination? And once they reach those conclusions themselves, not only can they put that on in court for the jury's benefit through their own testimony, but they can also help the lawyer better understand the evidence and the significance of whether evidence was missed, evidence was mischaracterized, misunderstood, or distorted in such a way that it's going to mislead the jury as to its importance or lack of importance.
And to illustrate that, let's say, for example, a medical examiner mistakes an entrance wound for an exit wound. That could be the difference between believing that someone was shot in the front or in the back. And if you shot someone in the back, it's a lot harder to claim self-defense. Not impossible, of course, but not a lot harder than if they were shot in the front. And that's a big deal.
I would say that makes quite a difference in how you're assessing the case and how you're going to present the case. And I think how the jury is going to decide the case. Absolutely. And that's a perfect example of how something that we might otherwise just defer to an expert.
Yeah.
You can't just let them say it because they say it without questioning and challenging and scrutinizing and getting qualified experts yourself to do that review. And that's one of the, oh my goodness, what a value CCW Safe is in that regard.
Well, because one, you have to have qualified counsel that knows how to work with experts and the need for it. But then these experts generally don't work for free, and it can be expensive and the prosecution has the weight of the state government on their side and the budget that's commensurate with that.
They usually don't get hung up with how much it's going to cost.
Right.
They have resources, they have experts, they can bring in people anytime they want to do something, where it's always a question for the defense. Is there enough money to hire this expert? Is there enough money to hire this expert instead of that expert because they're better, they're more well-known, they're more credentialed? And can you spend an extra $50,000 to explore some things that you're not 100% sure will get you what you want, but it's worth the effort to see if it does?
Especially if it's something that might make or break the case. And yeah, I'd love to, maybe we're kind of wrapping up here, but to use a real life CCW Safe victory that we both participated in. We'll go back to Stephen Maddox, right? And he was at this motorcycle rally. He was attacked by this guy named Kelly Wilkerson 3 times, physically attacked and dragged to the ground by this guy. And on the 3rd time, he had his revolver and he shot him and ended up killing him. And I think that one of the reasons the prosecutor had it in for him was that he felt that when Kelly Wilkerson pulled up on his bike to approach Maddox, that Maddox went out of his way to shoot him at a distance.
That's right. That's right. That he has essentially shot him off his bike, shot him while he was still seated on the bike.
But our expert was able to present evidence that that wasn't the case. Can you talk us through that and show how that can make such a big difference in a homicide case?
There was a little bit of blood on the bike, and that's because Kelly Wilkerson had been injured in one of the prior attacks on Stephen Maddox. And the prosecution just jumped to the conclusion that that was blood from him being shot, and that was blood on the bike, which meant he was shot off the bike.
Yeah.
When in fact, Stephen Maddox had said, no, he got off the bike, he approached me, he came at me, and I didn't shoot him until he was within just a couple of feet of me. In fact, as I was trying to shoot him, now Mr. Wilkerson was 6'3", 6'4", 300 pounds. Stephen Maddox is 100 pounds less, 150 pounds less, and several inches shorter. Mm-hmm. Wilkerson was an overwhelming physical force. And Maddox said, no, he got his hands on me. We were wrestling, and he even took me to the ground. In fact, the last shot we were right next to each other, might even have been on the ground, sort of belly to belly. And the law enforcement just poo-pooed that. They didn't make anything of it because they didn't believe it. Prosecutor said he shot him off his bike. So we hired a forensic pathologist, a private medical examiner, who looked at the autopsy report, examined the photographs, made some interesting conclusions. In fact, the medical examiner had confused an entrance wound for an exit wound, which was pretty critical in reconstructing the sequence of the shots. But then the forensic pathologist also examined the clothing that Mr. Wilkerson was wearing at the time of the incident. And lo and behold, he saw something there that's fairly uncommon and probably would have been missed by the untrained eye. He took pictures of it. He brought those pictures to court, and he explained, which was then corroborated by other experts, that what he saw on Kelly Wilkerson's vest was the clear indication of what is known as cylinder gap. It just so happened that Stephen Maddox had a revolver. Mm-hmm. It so happened that when Stephen Maddox said it was fired when Kelly Wilkerson was basically on top of him, that was physically represented in the gunshot residue by the way the gun was held and the fact that when the revolver was fired, there was gases and particles and ash that actually came out around the cylinder of the revolver and made a clear marking on the leather vest that was reproducible. In fact, you could take the gun and match it up.
Right.
So 100% Stephen Maddox was telling the truth. The prosecutor's theory was debunked.
Right.
And as you said, when not more than an hour and a half or so, the jury agreed that Stephen Maddox absolutely acted in lawful, necessary self-defense when he shot Kelly Wilkerson.
Yeah, and I've talked to Stephen, and one of the reasons he believes he was arrested that night, he said that basically it was at a motorcycle rally on a Saturday night after dark, and the police were just predisposed to think that it was a fight that had gotten out of hand, and they may not have thought too much more deeply into it. And in fact, I know from our conversation before that the police ignored all sorts of opportunities to collect other evidence that would have been relevant. Sure. Yeah. They just thought, all right, you're just this guy who got in a fight at a biker rally and you're going to jail. And that said, I don't know that we've worked on a lot of cases that are where the defender is more justified, and not just justified, but Maddox had twice before tried to get away from his attacker, and the attacker pressed, and finally, when Maddox had sort of exhausted that, he did what he had to do, and then he went to someplace safe around the corner, got on the phone, and dialed 911. Right? I think
interestingly, Shawn, before the third and fatal attack, Stephen had called 911, and it was in the process of being connected when Wilkerson shows up again and gets on him.
So 911 called him back.
Yes.
Yeah.
Yes.
Right. Mm-hmm. And so
Stephen did everything you could expect someone to do under those circumstances, and did everything possible he could do not to shoot Kelly Wilkerson,
and still wound up being prosecuted. Now, luckily, he had our team behind him, and the jury was a good jury and saw their way through even mistakes in the evidence that the prosecutor had made. But that illustrates, I think, what leads up to the conclusion that we come to time and time again in these conversations, right? If the conversation is how can someone who's justified, i.e. innocent, be convicted in a self-defense case, it can be errors in interpreting the evidence, bad police work. It could be some slip of the mouth that you made before or after. It could be confusion about who was the first aggressor. It could be some action you made afterwards out of just terror and coming down from a life-threatening event that makes you look guilty. It could be the fact that there is a disparity of force, that the attacker wasn't armed. All these controversies. And then it could just be bad representation that does not know how to work experts or doesn't know how to prevent a burden shift in a self-defense case. All that leads up to the conclusion that if you can avoid using deadly force safely, that's always the best way to avoid a conviction.
Yes. First and foremost, that should be on the top of anyone's mind when they are headed towards something that they fear may be confrontational, that could possibly escalate. If there's any way to avoid it, you have not only saved that life you might otherwise have taken justifiably, but you have saved yourself years of heartache and perhaps the risk of a lifetime of incarceration, because once you pull that trigger, you really can't control what happens afterwards. You can have input, you can assemble the best possible team with the unlimited budget that CCW Safe provides, but you cannot control the outcome. And you can minimize your risk, but you can never eliminate it. So yes, I know it sounds like we are encouraging people not to defend themselves, and by no means are we saying that. If you have to defend yourself, then of course do decisively.
Yes.
But at the same time, if there's any way to avoid it by being smart earlier, please do that too.
All right, my friends, that's the podcast for today. Thanks for listening through to the end. The big lesson this week is that there's lots of things that you can do as a concealed carrier to eliminate the controversy in some of these elements of self-defense. The other lesson is that there are things that you can't even think of that could become critical at your trial, and it'll be up to your counsel and their experts to make that difference. We'll be back soon with more. Steve Moses will join us next time. Until then, everyone, be smart, stay safe, take care.
Because on its face, you can't go around shooting people.